Please state.
Happy New Year. Welcome to Oral Argument. The clerk may call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco on Wednesday, January 3rd, 2018 at 9 a.m. Case number S230568, Regents of the University of California et al. Petitioners versus the Superior Court of Los Angeles County responding, Catherine Rosen, real party interest. For real party interest, Alan Charles Delaro.
Ready, Your Honor.
And for petitioner Timothy T. Coates. Case number S239777, Newport Harbor Ventures LLC et al. Plaintiffs and respondents versus Morris Cirola World Evangelism et al. Defendants and appellants. For appellants Stephen W. Blake and Daniel Watts. And for respondents Grant Hermes. Case number S223698. The People, Plaintiff and Respondent versus Mark Buza, Defendant and Appellant. For Respondent, Michael J. Mongan.
Ready, Your Honor.
And for Appellant, J. Bradley O'Connell.
And we have joining us this morning a group of 20 students from the Amador Valley High School Competitive Civics Team. They're viewing this morning's oral argument session along with their teacher, Stacy Skylar. Where are you all seated? Welcome. Thank you for being here. Thank you for your focus on civic engagement and coming to the California Supreme Court. Council may begin when ready. Let me also say for the first case, Regents of the University of California versus Superior Court of Los Angeles County, Catherine Rosen, real party and interest. We do welcome the Honorable James A. Richmond, Associate Justice Court of Appeal, First Appellate District, Division 2. You may proceed.
May it please the Court. Consider the UCLA campus, Young Hall, Chemistry 30CL, the Organic Chemistry Lab on September 29th, 2009. Catherine Rosen has just watched, mouth agape, as quiet Damon Thompson cussed out the TA. Another student overheard Thompson say, "If you don't do something about it, I will." Catherine thought it was super scary, as she wrote to her boyfriend, particularly so because the TA was new from an out-of-state college, new to California, new to Los Angeles, first-year TA in a chem lab. What was he to do? More importantly, what was Catherine Rosen supposed to do 2 weeks later on October 8th, 2009? After all, Damon Thompson worked right next to her in the chem lab. Was she to stay away? Was she to come with a weapon? Or was she entitled to rely on UCLA authorities to do what they promised that they were going to do when they enrolled her? That is, to keep it safe, keep her safe.
Well, since we're talking about what was everybody supposed to do, what was the university supposed to do to achieve that? What is reasonable to expect them to do under these circumstances?
The university had procedures in place. They had undertaken to do what needed to be done. They just didn't do it properly under the circumstances of Catherine Rosen's case. And in fact, we quoted to you from an interview with Elizabeth Gongai, who was the head of one of these intervention teams, who mentioned that in 2009, 2010, they had considered 100 cases, intervened in 6 of them. They had plenty they can do. They had already excluded Mr. Thompson from student housing. They made him undergo special counseling. Meanwhile, he is begging for help. The very day that Catherine witnessed him cuss out the TA, he wrote Professor Bacher and said, "Could you put me in another section?"
Sorry, let me bring you back to Justice Corrigan's question, though. I understand all those facts, and you're getting a little bit into what the university did or didn't do, but her question is a little bit more general, as I understood it, which is, what should the university have done in a nutshell?
When we talk about, were you talking about standard of care or duty of care, Your Honor? Because what they should have done is a standard of care question, not a duty of care
Well,
question.
Can I ask you this question while you keep these two? Why should they do anything? Tell us more about why, in the legal sense, in the first instance of a threshold, why is there even a duty under these circumstances?
Well, let's back up then, Your Honor.
Yes.
Okay. You're the chief. You get your question answered first.
Okay,
That's a first.
great way to be persuasive.
What we're dealing with here is the statutory liability of public employees under Government Code Section 820, and that liability is coextensive with the liability of private persons. And the liability of private persons is that everyone has a duty of care, as this court has recently, to act as a reasonable person would in like circumstances. This court has examined that question at least 3 times in the time since we wrote our last brief. First, in connection with the third-party exposure to asbestos in Kasner. Next, in the crossing the street from the parking lot in Valisenko, and then most recently, just a week or so ago, in TH versus Novartis, where you talked about the third party, the liability of a drug manufacturer. In each one of those cases, you did the same thing. You went to the Rowland factors and you broke them down, because the principal rule is that duty is the rule, no duty is the exception. And while we see in the cases the language like the general rule is there's no duty to protect from harm from third persons, that's really the general exception, because the basic rule is that there is a duty, and that your task and the task
A duty to do what? A duty to warn? A duty to do what?
a duty of care, Your Honor, to do what a reasonable person would do in a like circumstance, given the fact that we have professionals here who are charged with this very, with these various policies.
This is it's kind of hard to talk about like circumstances because, as you know, in every one of these cases, the circumstances differ. That's kind of the problem in this whole area, is that we are trying to be sensitive, actually, to the varying circumstances as they present themselves. So I think one initial question that I would have for you, counsel, is to what extent are you relying on the particularities of the university environment here as the fulcrum of your argument? In other words, the duty you're describing, does it also apply to, let's just say, an ordinary workplace where there may be someone in the workplace who is a little, shows signs of being a little mentally ill or has an emotional disturbance of some sort? Are those entities also falling within your rule, or is this special to the context of university?
Well, actually, the case law as it's developed to this point, Your Honor, suggests that in the workplace there is a duty. And we've cited those cases to you. We even relied on that theory, a workplace duty theory. If you read the Court of Appeals opinion in this case, what we have is a duty to protect the staff and the faculty and no duty to protect the students in the classroom. I think the critical point about the uniqueness, to answer your question a little more directly, is that students in the classroom in particular are vulnerable. They can't, well, they can get up and leave, but really they can't for all practical purposes, because they have to be there in order to graduate. Organic chemistry is probably a requirement if you're going to do a pre-med degree from UCLA, and they have to take that, so they have to be there, and they're vulnerable. This is what Your Honor said in Kasner.
Let me ask you then.
Sorry.
I took organic chemistry. It's compelling. So
That's why we're all here.
So what about elsewhere on the campus? Are you limiting your argument to the classroom, which is what, you might say, okay, well, that's the core function, right? And as you say, the students have to be there, otherwise they're not going to reap the benefit of what the university has promised them or offered to them. What about other things? You're walking, you're engaged in extracurricular activity, or just living in your dorm, or you're walking from here to there on campus. Does the same set of duties apply in all these contexts anywhere?
Well, the same general duty of care that we all share, yes, but to answer your question, I'm confining my argument to the classroom. we don't have any facts in this record about any other place on the campus.
And I think I understood your argument to be in the classroom because, not that students are required to be there, but they're compelled to be there for the purpose of higher education, which is what they paid for or signed up for or receiving a scholarship for. It's more of a compulsion to be there. Unlike, I guess that's how you're distinguishing the alcohol-fueled parties off campus or some of the other activities that where students aren't compelled to be there as part of the student curriculum.
Exactly, Your Honor. I mean, no court has ever gone and said students are compelled to be in college, but it's that compelled attendance that's led the court to its decisions like CA versus William Hart, where you found a duty in the fact, in part because the students in high school are compelled to be there. And now we've moved on to college, and at least once you've accepted my tuition and you've accepted my fees, and moreover, you've extracted a fee for the very protection that you now say I'm not entitled to, we are compelled to be there.
But
Are
so
you also
if
limiting
counsel-
your argument to the classroom because the university has more control over that situation?
Absolutely, Your Honor. I'm also limiting my argument to the classroom
And
because,
the farther out you get from the classroom, the less control the university has.
well, campuses, yeah, exactly right. Campuses today are closed environments with all of the blue buttons and lights and buttons on the consoles.
UCLA is like a small city. So the farther out you get from that classroom, the less control the university may have over those situations.
Absolutely. I am concerned about what happens to students in other parts of the campus, but my case here today is about Catherine Rosen.
So it does raise the question, though, of how broadly this duty might stretch. And ultimately, I just want to understand, even if you're confining your argument here to what happens in the classroom, do you see a principal distinction between the scope of the duty when a student is walking to class versus when a student is in class?
You're on that very gray line between standard of care and duty of care.
And this is why I was asking you about it earlier, right? So I completely understand, as you do too, that there's a distinction between duty and ultimately standard of care, but I want to start to get a sense of what the implications are of analyzing role in this way, finding a special relationship this way, if that's what we do. And that's why I want to understand, ultimately, practically speaking, what are the consequences of your argument?
Well, the consequences, we can parse this out into, is she in the hallway, is she in the doorway, is she on the steps?
Yes.
And
So she's in the hallway.
okay, I think you have to then duty is, in a certain sense, is circumstance driven. Is it foreseeable? We apply the same factors. Is it foreseeable that this class of harm could happen to her in the hallway? Not whether Damon Thompson was foreseeable that he would hurt Catherine Rosen in the hallway, but whether in general, because your cases all talk about, when we're looking at foreseeability, we're looking at the type of harm, is the type of harm that we're talking about foreseeable?
And why isn't the answer yes? So if you're right that it's foreseeable that an attack can take place in the classroom, why isn't it foreseeable that it can take place just outside?
It could well be foreseeable, Your Honor. I'm trying not to argue a case that's bigger than the case that I was presented in this record. And as we know from the principles of judicial restraint, generally appellate courts try to decide cases as narrowly as possible. So I'm not here to argue for a broad campus-wide rule, although I believe one is justified.
But the reason we have to inquire on this, from my perspective, nonetheless, is that even if we're trying to decide the case on narrow grounds, we're trying to understand what the right rule is, particularly in a tort case. So we have to think about the implications. So sticking with that line of reasoning, it sounds like the duty we're talking about here would be about students, but it would be about employees as well.
I mean, in terms of the protective duty?
Correct.
Yes, I believe that law at least has not been established by this court, but it has been established in several cases that we cited to you in our briefs in the courts of appeal. And in fact, it's an anomaly, really, if you were to accept that line of cases and say, yes, we're not, obviously you're not in a position to overrule those cases today in this setting, I don't think, but unless you were to do that, at some point, we would have this anomalous rule that the faculty had better right to protection than the students they were there to teach.
And then to go back to Justice Corrigan's original question, if I may, I understand you don't want to go to standard of care, you want to focus on duty, but what are some examples of what would fulfill the duty from your perspective? A warning, some caution on the part of the university communicated to employees and students?
Well, look at the panoply of tools that UCLA had available to it in this case. They had this very comprehensive student code. It authorized them to do certain things, not the least of which was compel Damon Thompson to go undertake some counseling, the failure of which meant he couldn't register. They also had the ability to accommodate him, which they had done in the past. As I'm sure you're familiar with the record, there was a history starting in 2008 of Damon asking for help. These women in my classrooms are whispering against me, calling me stupid. And the day he cussed out the TA, he sent an email to the professor and said, put me in another classroom. They could have done that. It's not clear that the professor ever answered that email, at least from the record we have at the moment. But those are the kinds of things. It's not like...
Would there have been a duty here if UCLA did not have this panoply of services? If UCLA did not know that this particular student, Mr. Thompson, had these issues and this building history, would there then, under those circumstances, not be a duty in your mind because, A, it wasn't foreseeable because UCLA didn't have knowledge?
We have foreseeability at two levels, Your Honor. We have the Damon Thompson foreseeability, and then we have the overarching foreseeability of classroom violence, which the regents themselves recognized when they commissioned that campus security task force at the end of, certainly after the Virginia Tech tragedy. And in that, they say that's acknowledging foreseeability, right? Why would we set up a violent prevention team if we're not foreseeing that there could be violence? There would be no need to do that. Why are we charging? So in that sense, there was definitely foreseeability.
Let me stop you there. So in that sense, then, the case you're arguing for is a consequence is that all universities or institutions of higher education after high school would be required to have some kind of program or service of such because of this general atmosphere of foreseeability because of prior violence on college campuses.
They would have to do, it was foreseeable, and how they met that foreseeability and discharged that duty would be a standard of care question. I see that I'm out of time.
What would be the variables there? Resources?
Resources would certainly be a factor. I wouldn't expect a community college to have to do more than the University of California. Part of the problem, and part of the problem for the court, is the way the Court of Appeal phrased its opinion. If they said the University of California doesn't have a duty under these circumstances, we wouldn't be wrestling with this question. But they said there's never a duty by any public college.
Well, I think part of the quandary here is how that duty cashes out into actual actions, right? So would even a community college have to, in the forms that it submits to students, either in the application or on intake, now have to have a checkbox that says, have you ever suffered mental illness in your life?
Boy, you're stretching my imagination too now. I don't see why
that's very imaginary, counsel. I think that, I mean, if you say that there's a duty and these things are foreseeable, right, it's not that hard to actually ask someone a question, although it is somewhat invasive, but wouldn't that be an efficient means of trying to effectuate the protective duty that you suggest is present?
I'm not sure that I would agree with that, Your Honor, because we have this, we have, as the university has argued, we have this conflict now with the ADA laws and the privacy laws and what have you. And to be sure, one would have to weave, but the authorities are all uniform that those laws are not an impediment to effective threat assessment practices.
But counsel, if I may, just to extend Justice Liu's question a little bit, the other side of the coin is, why wouldn't the rule that you're proposing discourage colleges from offering mental health services? If part of what is implied, I think, in the rule that you're proposing is that to the extent that they gather information about students in the course of providing mental health services and counseling, that is part of what ultimately makes them responsible for dealing with consequences.
We're dealing with a multidisciplinary process here, Your Honor, and that's why it's incorrect, in my view, to focus on mental health, even though mental health is often what's going on here. And
That's fair. I mean, your rule, let's say, has some upsides, and I'll stipulate to that. But to the extent that there's a concern raised along the lines of what I described, is that something we should be concerned about? Is that something that we should not be concerned about?
It's my opinion that those judgments have already been made by the universities themselves. They have these teams in place. They have there to address mentally at-risk students. And at the end of this case, really...
Counsel, let me ask you this question as an extension of Justice Liu's question, Justice Cuellar's question. Can you tell us what UCLA should have done that it did not do?
What they had in place, they should have...
They had all of these procedures in place, but they should have done more.
No, they should have done right. And that's the distinction.
And right is what?
Follow the procedures.
What did they not do that they should have done?
They should have known about this in time, because the way the procedures work is to filter information to a central point. That's what Mr. Dysinger talks about in his book. That's what he talks about in his declaration. If you look at the expert declarations, the dispute here is really about standard of care. Everybody, the UCLA experts all talk about UCLA did everything they could in the context of this, assuming that there were a duty, and not that there was no duty and therefore they didn't do it right. They didn't do it properly. They didn't. Karen Monero didn't know that Damon had a history of violence until just days before he assaulted Catherine. So it's not so much about, it's not so much about nonfeasance here, it's misfeasance. It's just like the police officer in Lagutu who directed the person to the center median where that person was struck. That's what we're talking about here, and the question has been cast a little differently to this point, and we've sort of been drawn into it because of the way the regents have presented their motion in the first place. This is summary judgment we're talking about. We don't have declarations from any of these people who were actors. We don't know what they really thought. All we know is what they committed to emails.
So
and consequently, that's why we have trials, because if there's a duty, was it discharged? And really, in the end, that's what we're talking about. And I'm using a lot of my time.
I have 10 minutes on rebuttal.
Very well. Thank you, Your Honor.
May it please the Court. I think the Court's inquiry regarding the pragmatic implications of the duty proposed by plaintiffs is exactly part of the duty analysis. It's what Rowland contemplates. It's what the Court has used in every case, and I think it has a particular force in this instance, because we ask ourselves the question, what should the university have done? Damon Thompson's not someone who fell through the cracks. This is a person who was being observed. This is a person who was being approached for treatment. He was seen by almost 24 healthcare professionals over a 9-month period. He was succeeding academically. Was he an odd guy? Did he have problems? Yes. But were they predictably violent?
Does UCLA have a duty to protect students in the classroom?
No. Not from third-party criminal conduct that's unrelated to what's going on in the classroom, what's being taught.
But it does have a duty to protect them from something else?
I would suggest the Patterson case in the Court of Appeal. If you're doing a lab experiment and you have a professor who's instructing you and gives you something hazardous and doesn't teach you correctly, yes, we're not. There are ordinary tort principles still apply to the regents in the classroom.
So yes, from an exploding experiment
where a teacher
overseen
does
by a
something
professor,
wrong.
but no from another student stabbing.
From another student, from a third-party criminal conduct by a student.
So what is a student to do to protect him or herself?
They cannot come to class. They can complain, which is what's done. But ultimately, the question we're talking about here and the duty that the regents are being faulted for is not predicting criminal conduct, not predicting dangerousness. And one thing I would point out to the Court, that when the legislature has weighed into this area with respect to those professionals who are most qualified to make that determination, which are psychotherapists, they have established an extremely high level in order to get liability, which is an actual appreciation, an actual knowledge, an actual conclusion that this person poses a threat.
Do you disagree that UCLA had superior control over this particular risk of the third party? Under the facts of this case, we know that Mr. Thompson had a troubled history and some experiences and record that indicated he did not get along well with others, was paranoid, had been kicked out was reporting, one team knew that Mr. Thompson was having these difficulties because UCLA provided the services.
Correct.
So in this particular instance, when you were answering Justice Cuellar's question that the student should complain, what pops into my mind is under these circumstances, with this panoply of services and this history, that UCLA had superior control over this particular risk. It's hard to know why Rosen would expect that she would get stabbed in the classroom.
Well, it would be hard to say how the regents would expect that she would be stabbed in the classroom. Again, we're talking about foreseeability of criminal
Right,
conduct.
and that might be foreseeability, that might go to causation, and might go to breach. But in terms of a legal duty here, do you disagree that UCLA had superior control over this particular risk?
For purpose of foreseeability, the Rowland factors
Well, my
include
question is,
foreseeability with a
Do you
capital
believe
F,
UCLA had superior control over this risk?
as opposed to Catherine? No. Because I don't think anybody's in any better position to assess dangerousness, and that's the entire point, right? That's the point of the legislature when they address the liability of those trained professionals. People, this is what they do, right? They assess dangerousness from people who are suffering from mental
I
illness.
don't want to go back to the record, but I understood that Mr. Thompson said a few times that he would hurt people or that he would take
No.
it into his own hands.
That is, I will tell you, the dispute that we have with the plaintiffs, much of what they talk about Mr. Thompson's threats comes from his interview after the fact at Patton State Mental Hospital. In the record, the complaint about I'm going to do something about it is I'm going to complain to the dean, which is what he repeatedly did. This is a gentleman whose only violent act prior to this was a shoving match in the dorm. That's it.
And I don't want to get into a fight with the record because I don't want to use your
Correct.
time, and this can be, but my
Correct.
understanding is at the CAP session, Thompson admitted thinking about harming others. He had no plan. He wanted to harm the people insulting him, but could not attribute to specific individuals. There was other information. He thought about it. He wanted to hurt the other residents, decided not to hurt anyone. To my original question about who has superior control over this
Correct.
risk, I take issue with the student should report this or not come to class.
Well, I mean, 2 points here. One, if the court looks at the briefs, I think you'll find in the record the discussion about his dangerousness. He would discuss these things. He would tell the professors, yes, but I'm not going to act on that. I am not actively that way. And that includes, I think it's 8 or 9 days before this attack when he was assessed by a trained mental health professional.
So all of my questions and even your response go, frankly, to me, to something beyond the threshold question of legal duty. Yours go to maybe causation or standard of care, what more could have been done. But I think the question that we are asked here is whether or not, in the first instance, there is a special relationship requiring a legal duty by UCLA to protect, warn against a student who happens to be, in this case,
Then the source of the special relationship becomes critical. Because if the source of the special relationship is because we extended treatment to Damon Thompson, and you look at one of those things in the Rowland factors, what are the consequences of imposing that? What you're telling people is don't have these outreach programs.
So can I ask you, if you set aside the history of his treatment and you set aside the dispute over how much the record revealed about the nature of his threats before the events that gave rise to the suit took place, say that the professor in the class or the TA becomes aware of a specific and credible threat from one student to another, hypothetically, abstracted from this case. The university has no history of treating this person for mental illness, but a person who's not a trained mental health professional becomes aware of a specific and credible threat of violence to another student in the class. Would you agree that the university has a duty of care in that scenario?
I have got to stop you at the outset of that premise, that notion that it is a credible and realistic threat. One of the most difficult things to predict is the realistic threat of violence. Even therapists don't get it right, trained psychologists. So the notion that an average law professor or college professor is in a better position to determine whether something is a credible, real threat of violence, as opposed to the duty that the legislature has placed on psychotherapists under the Terezov statute. I think that just makes no sense. I think it should caution the court against finding some sort of general free-ranging duty to warn under these circumstances, because you are effectively saying that lay people have a lower level of liability than trained professionals to assess and determine whether someone presents a credible threat of violence. And so I can't take the court's...
So it would, the consequence of that view would be that if, for whatever reason, a the TA becomes aware that one student has a real vendetta against another and intends to do harm, that the TA would be justified in not communicating that threat to anybody else and not taking any measures to try to make sure that the students are separated, could do absolutely nothing and just sort of watch these events unfold.
The general for all of us is, in every situation, is you don't have a duty to try and prevent third-party criminal conduct. You don't, unless you've done something to increase the harm, unless there's a special relationship that makes it more likely that that harm's going to occur.
And the student-university relationship is not a special relationship in this
It is not a special relationship. No court has ever found it to be a special relationship. The court in the Avila case said that there's certain university activities that there's an obligation not to increase the hazard from it.
So look, I understand your reluctance to go in the direction Justice Kruger was leading, although, and I understand your hesitation about embracing the premises of an example that might blur the distinction between a layperson and a trained professional, as you're saying. That said, it is difficult to cast aside that an implication of your perspective is that even in situations where a university collectively, not just one layperson in a university, but an institution that is filled with experts of various kinds, does not have some duty, even if information is enormously credible. So, just to extend Justice Kruger's hypothetical a little bit, we're talking about a situation where it's not the TA inferring from a stray comment that one student can pose a risk to another, but maybe a psychotherapist walking by the classroom hearing somebody say that they want to do harm to another student, one student to another. Like, I want to understand whether there's a limit to your argument or whether, your argument has the benefit of the clarity of, I'm drawing a very bright line, it's just there's no special relationship, there's no duty, end of story.
Yes. I like the example Your Honor gave of the psychotherapist walking by and makes this assessment. Now, the psychotherapist, unless they have an actual belief with respect to that person presenting a danger, they are not liable. But under the hypothetical posed, if there's a lower duty of care, the TA is. I mean, that's the implication of that rule. That's the implication of that rule. And I think that's why you don't find a special relationship, because the implication of that rule is you have professors, you have TAs reporting all sorts of odd behavior.
Just to pursue this line of questioning one more step.
Sure.
Your understanding, I think implicit in your view of the Rowland factors and everything else, is that the right level of generality at which to inquire here is about the dangerousness of one particular student, not about the level of dangerousness that might be faced collectively by a student population.
Society at large.
Or not society at large, but by a
the
group of students
community.
relative to another group of students.
Correct. And I think this court has used that analogy in its duty cases, in NM and the Sharon P. cases, in talking about what's the duty of a shopping center, what's the duty of a parking lot owner. The court said, well, it doesn't include providing security guards. Why? Because we're going to do the duty analysis and say, what's the closeness of the harm, what's the social utility in doing it, what are the implications of placing that burden on these property owners. And you apply that analysis here and you say, okay, you've got to predict dangerousness, right? Lay people, you've got to predict dangerousness. You have to call up the ladder. You have to tell people.
Why you keep returning to this point, but I guess I go back to the Chief Justice's question. Why are you not confident that the elements of breach, causation would screen out all the worries that you are laying before us? I mean, this is just the threshold inquiry here. There's so many other hurdles that a successful litigant would have to cross in order to get to liability.
But the whole point of the duty analysis is to identify that potential, what that reasonable conduct will be, because you're going to act in accordance with what your duty is, right? You're going to change your behavior. And so you absolutely focus on the pragmatic implications.
So all your arguments are perfectly good arguments as to the reasonableness of the behavior. You're telling us it is not reasonable to expect lay people, TAs, faculty, to diagnose dangerous behavior. It may be reasonable in certain limited instances for actual trained psychotherapists, which I assume UCLA does employ, to identify these things. But at the level of the breach, it is a narrow set of circumstances. And you're making exactly those arguments. Great, those are terrific arguments, but they're directed somewhere else.
Well, if it's psychotherapists, if we're talking about that, then there's adequate liability under existing law vis-a-vis the psychotherapist. What we're talking about is not creating a general tort liability duty with a standard of liability that's much lower than that imposed on the therapist. And I submit that under this Court's cases, whether it's A&M, whether it's Sharon P., whether it's Rowland, you absolutely look at what the specific duty is that you're going to impose. And it's not standard of care. You're talking about what are the practical implications of this rule. And if the practical
before you run out of time, I'd like you to address a broader question that was asked of opposing counsel. Your friend on the other side has asked us to limit the examination to duty within the classroom or the lab. Questions were asked from the court whether or not it should be broader. What is your response?
My response
I know
is,
you don't like the first premise, but what is your response?
I like the other premises even less, that it goes beyond the classroom, but I think the Court's one focus here is important, which is in the university setting, unlike K through 12, the line between learning environment in the classroom and elsewhere is much more blurred. Learning takes place all over the university campus, and there are libraries and plazas. It is a much more fluid environment, and I think, as everyone has talked about, more akin to a city, particularly UCLA, than the normal K through 12 setting, which was fairly limited. So the plaintiff's postulate is we start in the classroom, but, okay, you have to use the hallways to get to class. Is there a duty there? You have to go onto campus to go to class. Is there a duty there? And what we're talking about is a difficulty in cabining this both on a geographic level and also on a substantive liability level. And that is that what do you want us to do? And that absolutely is part of the duty inquiry.
So following up Justice Liu's question, then, you seem more comfortable recognizing the psychotherapist as an expert and conceivably is in a position to make a judgment about a particular threat. So your duty analysis suggests that even if a psychotherapist concludes that there is serious danger and warns his or her employer, the institution still has no duty to act.
Correct. Correct.
Thank you for being clear.
I find that really hard to swallow. I mean, let me back up about UCLA generally. I think it's more than just a city. It's a living community, is it not? I mean, doesn't UCLA portray itself as a community? Insofar as students who go there, it's a 24/7 kind of experience, is it not? Isn't that how you sell UCLA?
It's more like a city, yes.
And in that respect, it is different than, say, I don't know, a restaurant where patrons come and go. They may be repeat players, but not repeat players in the same configuration. It's different from a K-12 school where kids go home to sleep at night. There's a clear division usually between parental role and what the school officials do. Here, the students, by your invitation, by your school's invitation, are there on a sort of living 24-hour, 7 days a week basis, which gives the university, I think, both a special degree of control as well as a special corresponding degree of responsibility over the conditions under which this living community or educational experience occurs. Isn't that how UCLA portrays itself?
It is a community. It is a city. Most cities portray themselves that way.
But then you make no promises, no warrants to the students that you will be safe in this environment.
Of generalized safety? I mean, as the court noted in the Zelig case, it talked about the County of Los Angeles and the courthouse. And we're dealing with a public entity here. UCLA is a city. It has a police force.
What warrants do you make to the students about their safety at UCLA?
Just generalize that we try to take their safety seriously.
To tell us that those are unenforceable promises?
They are generalized, unenforceable, aspirational promises. This court, I've never seen a case where this court has enforced such general aspirational promises.
Your answer is yes, just to be clear.
I'm sorry?
They are unenforceable promises.
They're
yes.
correct. They're
I'll
statements.
also ask this question.
Yes.
When I went to college, it was a free-for-all. There was no one at the dorms. You didn't have to check in your license. There were no blue lights on campus. There were no shuttles. There was nothing. And so all of us on campus knew you were sort of on your own when you were driving at midnight away from the library. And yet now, on campuses, you see blue lights at every 100 yards. A parent taking a tour says, "What's the blue light for?" And they say, well, it's a student can call for an alarm if something is happening on campus. And what about when you're coming home from an urban campus at night and, well, you can take the shuttle, or you can call for an ambassador to take you from the library to your dorm. And all of these things are part of the package. It gets a parent to pay $60,000 a year when they send off their helicopter child to a university about safety. Are you saying that those aren't implicit promises of a special relationship to protect the child?
Correct. That is a statement that we're trying to make a world safer that isn't inherently safe. But to say that you're going to create a tort duty because you've undertaken efforts to provide safety.
Whether or not that creates a special relationship from which then scope, standard of care, causation, breach, et cetera, reasonability, foreseeability would then be litigated if a child is injured seriously by a third party on that campus amongst all of those
because what does it mean to have a general statement that we try and make the campus safe? You can't create a specific duty from a generalized statement.
But your argument goes well beyond that, right, Counsel? I just want to be clear,
Sure.
and I appreciate that you've been clear, I think.
Yes.
Your argument is not only that the university doesn't have any enforceable, generalized safety responsibility, but also that it doesn't have a specific safety responsibility vis-a-vis a very credible specific threat about one student potentially harming another.
Unless we fall within one of the traditional special relationships, if we've somehow increased the harm. And I think it might be arguable if you absolutely knew, if a therapist said this guy is absolutely dangerous, then it might be a different situation because you are putting him in proximity deliberately.
Counsel,
but that falls within existing special relationship doctrine, and they've pretty much kind of tossed that aside and said, well, that's not what we're talking about.
I appreciate the vigor of your litigating position.
Yeah.
But I must say I find it astounding that you would welcome a headline from this argument that says UCLA's promises of student safety are not enforceable in law.
Not enforceable via contract, not enforceable via any representation of generalized safety. What does it mean to have a safe campus? And I think that's what we're talking about here.
But, I mean, the very question you pose, don't you think is one that parents and students enrolling in UCLA would like an answer to?
They would like to know, do we have a safe campus? Do we try to make it safe? Do
You
we do
say in the
everything
glossy
possible?
brochure
Yes.
that UCLA is a safe campus. What are they entitled to expect?
They're not entitled to expect complete protection from all third-party criminal conduct. I mean, I think aspirational
Okay, so
statements.
so let's go from there.
Sure.
Okay. I mean, in other words, if you could just assume with me for a second that your bright line rule may not carry the day here, what would be the next best position for you?
I'm not certain if I take the court's point.
Suppose you don't
If we are going to
persuade us,
find a
Jeff.
duty of some sort here, right, how would you phrase the duty? I mean, I assume you're going to phrase it in the most limited way possible, but I would like your answer to a second best situation for you.
Well, it would be within the context of existing case law, which I think would mean that there would be no liability here. There would be no duty here, which is under the special relationship doctrine where there has specifically been undertaken action by the defendant that made a particular plaintiff less safe.
Does your argument also apply to employees? Does the university not have any tort duty to protect employees?
The university has a duty through the labor code to take certain actions with respect to employees where, by the way, the legislature has not acted to do the same thing with respect to students in the college environment.
But under tort law, there's no duty.
Not under that, no.
Could I mean, not to touch on yet another third rail subject, but does your argument extend to the notion of sexual assault as well?
In the dorms, in the classrooms?
Everywhere on campus. Since it is a topic of very current interest, the university has no duty under your theory to protect its students from sexual assault by other students. That conduct is, in some cases, criminal.
It is, but it's third-party criminal conduct.
And you're going to tell us here in court that the university, by your position today, also has no duty to protect in those instances?
The university imposes internal regulations and standards to address those situations. But as the court has noted...
No duty in tort.
There's
That's your
no duty in
position.
tort.
There's no duty in tort.
Existing case law has suggested there's no duty in tort for the very reason that because of the size of the university, because of the breadth of the university setting, that it's not like K through 12. We have the time.
Further question then. So under Rowland, which is part of what you're applying here, there are multiple factors we consider. But let me just ask you about the moral blameworthiness factor, right? And let me stipulate that that is not the entire Rowland analysis. So there might be offsetting factors. But under moral blameworthiness, does the university not have some duty here?
I think particularly in the context we're talking about here, no moral blame. Here we have Damon Thompson, a very troubled individual, an individual that was, received treatment from the university because they have outreach programs specifically to address people like Damon Thompson. So if anything, I think the blameworthiness of the conduct here is very slight for the Regents. This is an extremely troubled young man. We're being faulted for not doing the most difficult thing there is, which is assess the dangerousness of an individual, and we're facing a rule of liability that suggests that untrained individuals should be held to a lower standard of care for a lower liability than trained professionals.
You had mentioned that one option is for a student simply not to attend class. Does that not call for the same kind of lay judgment that you believe the university is not in a position to engage in?
Everybody makes this decision every day when they're walking down the street, whether they think that person down the corner seems too odd to walk by.
And the university is in no superior position to that student?
Because the difference there is liability. No, it isn't. It isn't. And the legislature...
How often are these kinds of third-party criminal assaults by a fellow student-on-student happen in the UC system?
Our indication is it's rare. I don't think there's been another classroom incident since this one.
Then if rare, what's the downside of finding a special relationship for legal duty just at the outset, and then litigate the other factors that might respond to liability?
For the reasons I said, there's the court's analysis, and Roland talks about, you look at what that reasonable conduct might be and what burden that's going to impose in anticipating it, because we want to avoid future lawsuits.
But the public policy would seem to weigh in favor of, if it's rare, then imposition of the legal duty would mean that you would not necessarily be liable at the end of the analysis of a tort case, but that public policy would say, if it's rare, then maybe universities or higher institutions of higher education should in fact provide these services for these students to protect and find this special relationship, because we're not worried about a flood of lawsuits on the back end of this.
Well, it's the other way around, I think, under the Roland analysis, Your Honor, which is you look to see, how much of a danger is posed by the rule that you're suggesting. If these kind of attacks are rare, what I submit is you don't create a new rule of liability of special relationship to encompass this one out there possibility, to which our reaction has to be, as responsible educators and such, to avoid tort liability, now that duty's been imposed, is to take these other actions, which is having the TA report anybody who seems to be mumbling to themselves, or in some circumstances, universities not admitting these type of students at all. I think, as we note in our...
Talking about standard of care that would evolve over case law and over circumstances of the case, but in this particular instance, if there were a special duty, it still doesn't necessarily mean, based on all of the things you said here today, that at the end of the day, UCLA would be liable for this particular assault.
But the reason why we focus on what it takes to be, quote, reasonable is part of the Roland inquiry, because you're talking about what's the burden of imposing that duty, because we need to act reasonably in the first instance. So what are we going to do to guard against that? And what we're going to do is have TAs report everybody who's mumbling, encourage students not to get along with students who are a little bit different. This may discourage enrollment by students with special needs. It may discourage universities from admitting students with special needs because they create problems. And in fact, I think we note in our brief, some of the private universities already have started doing this. You don't create a special rule and a gross expansion of California tort law for what is essentially a rare incident. It's the other way around, I would submit, Your Honor, under the Roland factors.
The problem here, you make some compelling points. I think there are some obvious perverse incentives that could come from recognizing a rule, including the questions asked of opposing counsel regarding whether schools would then simply avoid funding mental health or creating mental health services, because if you can't be liable for what you don't know, right? So that is one problem. And then of course you could have over expulsion or under enrollment of certain students who you deem to be potentially problematic, and these are all very, very legitimate concerns. I think that the argument about the rarity of this kind of incident masks, I think, the breadth of your theory, though, which is, I mean, not to return to the other subject, but it would seem the more common scenario on campus is other kinds of misbehavior of student on students, not least of which is the sexual assault issue. And I would think that what you're arguing here today encompasses that set of scenarios as well, which is no longer in the rare category, but in the, I would say, quite not unfamiliar category, right? So what are we to do? You're asking for a very broad rule, but on the other hand, you're saying that there are a lot of reasonableness kinds of tests that we should be applying, I would again suggest, why not, load those into the regular tort elements rather than simply saying at the outset, well, there's just never going to be a situation where the university should be on the hook for this.
Well, I think
So broad.
I think this case comes out of the classroom, very specific classroom setting. What you're postulating is a duty of care that may or may not include other settings. And my point to the court is maybe you wait for that other case. Because I think that's part of the problem with postulating when you impose a very broad duty, which is what they're talking about here, that you do have that danger. We're talking about predicting criminal third-party conduct in the classroom in this case. There is no existing duty under the case law for that. The court would be creating that. It would be finding a special relationship where no court has found a special relationship. Maybe there are other contexts. I don't know. But as we have here in front of us, when you talk about what kind of conduct the regions are being held liable for, which is a failure to predict violence, a failure to predict dangerousness, and a failure by lay people to accurately do that, I submit that existing case law counsels against the court doing that.
You're asking, in a sense, for the mirror image rule. You are asking for a narrow rule, just the mirror image one that your friend on the other side suggests, that you would limit your no-duty rule to the classroom and criminal behavior.
We've had that. That is what is here, and that is what is before the court. And I think other cases may well fit into other existing doctrine recognized by the court, and the court waits for that case.
I see that as a perfectly sensible minimalist concession, but on the other hand, counsel, it seems to me part of what you've argued with particular vehemence and intensity is this point about lay people, it's this point about the difficulty of predicting criminal behavior, it's this point about the university not being in any sort of special relationship to its students. So I must say, even though you are pressing us to try to be narrow here, I have a hard time seeing how, if we accept your argument here, we might reach a different conclusion in related contexts.
You might in related contexts, but other contexts might have other relationships between the regents and the students. They may be in a landlord-tenant relationship where there's a landlord-tenant contract. Some of the cases out there that talk about that haven't reached that issue. And so that's why I'm saying other scenarios will have other legal duties imposed through other ways. And I don't think the court wants to postulate now as to the broadest scope. If the court has any further questions, I'd be glad to respond. Thank you.
Thank you, Mr. Coates.
Not sure quite where to begin. Let's start with moral blame. I think it's morally blameworthy, as you've said in Kasner, where the students are particularly powerless, unsophisticated compared to the defendants. Isn't that the situation that we have here? And without elaborating on that too much, because I don't have a lot of time, and frankly, I think you have the issue really well in hand at this point.
Counsel, what about the argument that your friend on the other side pressed about predicting criminal behavior? Is there anything particularly special about the idea here that this was criminal behavior and it kind of is a high threshold, and who can foresee that kind of thing? Certainly not lay people.
Well, there's a number of inaccuracies in counsel's statements about what we're dealing with here. I question to you whether Damon Thompson's behavior is criminal in one sense. He's in a Atascadero for the criminally insane. But in another sense, when we're talking about lay behavior, those are not the people we're asking to make these judgments. Adam Getz did what he was supposed to do. He reported it up the chain. It wasn't blameworthy on him. They had these specific procedures in place, and they weren't just, they're multidisciplinary, multiple disciplines involved, not just psychotherapists. We're not imposing a higher duty on these poor lay professors. If you noticed in my brief, we talked about Dysinger's 5 factors to predict violence. There's threat assessment factors. The professor notices something in the classroom. That happened here, and he reported it. The dorm supervisor notices something in the dormitory. That happened here too. They kicked him out. The campus police noticed something because there's a disturbance. That happened here as well. Campus police came, they interviewed the other kids in the dorm. And then we have the psychotherapist professionals themselves. And I submit to you that an inference can be drawn here that a jury would be allowed to draw that the psychotherapist in this case, Nicole Green, in fact, had the information to trigger the liability under Section 43.92 of the Civil Code. But as Justice Perlis points out in his dissent, you don't really need to go there with me on that, because even if she's not in the case, we still have a duty. This.
So can I ask you, so how does the duty work in a situation in which we're talking about a university that doesn't have as elaborate a system in place for dealing with the mental health conditions of students? So all you have is my hypothetical of the TA in the classroom who hears one student making threats against another student. There's no team of psychotherapists on hand to make a sort of a more medical-based evaluation. What is that TA to do? How does the duty work?
Well, the duty is to protect from and warn against foreseeable risk of violence. If it's not foreseeable, there's no duty. If the TA at San Francisco City College doesn't, if we can step back as reasonable people and say he couldn't have foreseen anything here, then there's no duty, there's no liability.
So far, I've heard you say that the TA did what he was supposed to do, correct? The campus police did what they were supposed to do, correct?
No, that's not correct.
Okay, did I miss something?
No, yes, Your Honor. What I was
You got to the psychotherapist and you said they did something wrong.
No, I'm sorry if I misspoke. I didn't make it clear.
You can explain the whole thing to me.
I propose to do that. Threat assessment in this context involves an upward funneling of information. And those sources that I just enumerated for you are the sources of that information, and they are supposed to go to this threat assessment team, the so-called professionals. That's what the UCLA experts say. That's what our experts say. Our experts say they didn't do it right, and that's why Catherine wasn't warned. Their experts said we did everything we possibly could, and consequently, there was no.
Who did not do what they were supposed to do?
Nobody issued a warning. There was certainly no dispute that there was no warning. They went looking for Thompson but couldn't find him in those hours and days before this happened. They were undergoing this frantic search. There was an urgent call to student housing, and only then did the people charged with doing this learn that that Damon had been kicked out of the student housing months before. This funneling of information didn't occur, which would have triggered the need to do something. But you're kind of entrapping me in the weeds, not entrapping, but we're wrestling in the weeds of the standard of care, in my opinion, rather than in the duty of care. It's almost breathtaking to hear the regents of the University of California say, there is no greater priority for the University of California than the safety and security of students, faculty, staff, and visitors, and to say that's merely an aspirational platitude, which I think I just heard counsel tell you that. There's no source of public policy greater than the state of California's Constitution, and that Constitution says the same thing, that students have an inalienable right to safety in the classroom. Any other rule, in our opinion, any other rule defeats those purposes, makes a sham of both the statements that the university makes to its parents, to its children, just as the Chief Justice noted in her questions. And in our view, the court should reverse the judgment of the Court of Appeal, remand with directions that it deny the petition for writ, and let Catherine Rosen have the trial that she deserves. Thank you.
Thank you, counsel. The matter is submitted. In the matter of Newport Harbor Ventures LLC et al. Versus Morris Cerullo World Evangelism, we welcome the Honorable Vance W. Ray, Administrative Presiding Justice of the Court of Appeal, 3rd Appellate District, presiding as pro tem. Whenever you're ready, Mr. Counsel, Mr. Phillips.
Good morning, Your Honors. May it please the Court, I will be presenting for approximately 15 minutes, and I'll reserve 15 minutes for co-counsel for rebuttal. We ask the Court here today to reverse the 4th District and hold that an anti-SLAPP motion is timely if filed within 60 days of service of a complaint, which includes an amended complaint, regardless of when the SLAPP allegations first appeared. There's 3 main reasons we believe the Court should rule in this way. First, it's consistent with the statutory text. Secondly, it's consistent with the statutory purpose. And
What's the
lastly,
purpose of the anti-SLAPP motion?
well, there's several purposes that this Court has articulated, but in Burrell, the Court said the anti-SLAPP procedures are designed to shield a defendant's constitutionally protected conduct from the undue burden of frivolous litigation.
And to do so by resolving these matters expeditiously.
Absolutely.
Well, it seems there's some tension between the rule you would have us articulate and the goal of expeditiously resolving these claims.
I don't agree with that, Your Honor. And
What?
the statute, as this Court knows, the statute itself creates a time limit. It says it right in the statute, where it says that a litigant can file a special motion to strike within 60 days of service of the complaint. And that's the rule that I believe is consistent with what the statute, what we're asking for today, is that the timeliness of that motion is triggered by the service of the complaint.